Good afternoon, everyone, and thank you for joining us today. Before we begin the session, I would like to briefly introduce Uniqey by JJ Tax. JJ Tax was founded in 2019 with the objective of simplifying taxation, compliance, and legal services for individuals, startups, and businesses. Through our mobile-based platform, we provide integrated solutions for direct taxes, GST, corporate, and startup compliances, and legal advisory services, all in one place. Today's session is titled Understanding Your Legacy, a guide to wills. I'm Advocate Arushi Shukla, and through this session, we will discuss the importance of wills and estate planning. Most people believe that wills are required only at an old age by very wealthy individuals. However, estate planning is not about age or wealth. It is about responsibility and foresight. I have personally seen families face years of litigation because a young earning member passed away without a will. Planning early avoids such hardships. By the end of the session, you will understand why every earning adult should consider having a will. So, what is a will? A will is a legal document in which a person clearly states how their assets should be distributed after their death. It answers crucial questions such as who will receive what assets, in what proportions, under what conditions. A will can also specify guardians for minor children, ensuring they are raised by someone the parents trust. Beyond its legal value, a will is an emotional safeguard that prevents confusion, disputes, and distress amongst family members. In many families, dispute arises not because of greed, but because there is no clarity, and a will provides you the clarity. So, who can make a will? Any person who is 18 years or older can make a will. The individual must be of sound mind, meaning they understand the nature of their assets and the implications of the document. The will must be made voluntarily without any pressure, coercion, or undue influence. If a will is made under pressure, it can later be challenged in court. There are cases where elderly individuals were influenced by relatives into signing documents, leading to prolonged litigation. A proper executed will avoids such situations. So, why is a will important? A will basically ensures that your assets are distributed exactly according to your wishes. If there is no will, the distribution of assets happens as per succession laws, which may not reflect your personal relationships or intentions. A will helps prevent family disputes, reduces emotional and financial strain, and saves time and legal costs. It also allows you to include people or causes that may not be recognized by as legal heirs under the law. For example, someone may want to support a sibling, a dependent friend, or a charity, which would not be possible without a will. Now, what all can be included in a will? A will can include both tangible and intangible assets. Tangible assets include property, land, jewelry, watches, vehicles, paintings, and personal belongings. Intangible assets include shares, bank accounts, investments, intellectual property such as patents, copyrights, digital assets, and online accounts. In today's digital age, many families are unaware of online investments or digital assets held by the deceased. A will ensures that nothing is lost or overlooked. Who all can be beneficiary in a will? A beneficiary is any individual or institution named in a will to receive assets. Beneficiaries can include family members such as spouses, children, parents, siblings, and also include friends, colleagues, or caretakers. Institutions like NGOs, educational institutions, and charitable trusts, in fact, can be beneficiaries. Through beneficiaries, you can decide how your assets and values continue beyond your lifetime. Yeah. Who all can be included in a will? A will provides significant flexibility. You are not restricted to naming only legal heirs. You can include stepchildren, friends, dependents, or non-relatives. This flexibility is especially important in modern family structures, second marriages, or blended families. A clearly drafted will avoids these misunderstandings and emotional conflicts amongst family members. Including pets in your will in India. Pets are not considered legal persons and therefore cannot inherit assets directly. However, you can appoint a caretaker for your pet and allocate funds specifically for their care. You can also provide detailed instructions regarding food, medical care, and daily needs. The executor of the will ensures that these instructions are followed. There have been several recent instances where pet owners ensured lifelong care for their pets through well-drafted wills. Now let's discuss a famous case. It was Gayatri Devi's will. In case of Gayatri Devi's will is basically a very landmark example which highlights the importance of clarity in wills. Her will designated assets to her grandchildren. However, her stepchildren challenged the will, claiming rights as legal heirs. The matter went to multiple levels of litigation. Ultimately, the Supreme Court upheld the intent of the testator, reinforcing the importance of a legally sound and clearly drafted will. How can we make sure that a will is properly executed? The person's called an executor. An executor is the person appointed to ensure that the will is properly executed after the death of the testator. The executor manages paperwork, assets, and coordination with authorities. They ensure that debts and taxes are paid and that the assets are distributed according to the will. Appointing a reliable executor significantly reduces the burden on family members. In cases where no executor is appointed, families often struggle with banks, courts, and administrative authorities. So, who can be your executor? An executor must be an adult of sound mind and not legally disqualified. They can be family member, trusted friend, an advocate, or even a financial institution. The executor applies for probate if required, manages assets, and ensures proper distribution. A beneficiary can also act as an executor, provided there is no conflict of interest. Many people prefer appointing a professional executor to avoid emotional conflicts within the family. So, how to get a will registered? Registering a will is not mandatory in Indian law, but it is highly recommended. Registration adds authenticity to the will and significantly reduces the risk of disputes. The process is simple, affordable, and provides long term peace of mind for both the testator and their family. The first step is drafting the will with the help of a legal professional. The second step is scheduling an appointment with the sub registrar's office within the relevant jurisdiction. The testator must visit the registrar office with the original will and some basic documentations like two witnesses, identity proof, address proof, and passport size photos, etc. There is no stamp duty payable for will registration and has only a nominal registration fee, making it one of the most cost effective legal safeguards. A registered will carries greater evidentiary value in court. It is harder to forge, tamper with, or challenge. Since an official copy is maintained by the sub-registrar while registering the will, it offers an added layer of protection against disputes and fraudulent claims. Now, what is the difference between a will and a gift deed? A will becomes effective only after the death of the testator and can be modified or revoked at any time during their lifetime. A gift deed, on the other hand, transfers ownership immediately and is generally irreversible once registered. Gift deeds also attract stamp duty, whereas wills don't do that. Understanding this difference helps individuals choose their appropriate method for asset transfer. Now let's look at some interesting data on wills in India. Less than 10% of the Indians have a will, which is a major reason for the large number of property disputes in the country. Will drafting usually costs between 10,000 and 15,000, while obtaining a succession certificate can cost significantly more and take several months. Many myths, such as wills being only for the elderly or e-signatures being valid, discourage people from planning in advance. In the end, estate planning is not about fear or pessimism. It is about foresight and care for your loved ones. A will is a final act of responsibility that protects your family and perceives harmony. Uniqey assists individuals in drafting and registering wills with complete legal support. Thank you for your time and attention. I'm happy to answer any questions if you may have. The floor is now open for questions. You can send your questions in the chat box. So there's one question from Mr. Keshav. Is registration of a will compulsory? No, registration is not mandatory under the Indian law. A will is valid even if it is not registered. However, registration does help and reduce the disputes, provides authenticity, and makes it harder to challenge later. Ms. Anshika asks, can a friend be a beneficiary in a will? Yeah, definitely. A friend can be. There is no restriction that beneficiaries must be family members. Any member, including a friend, can be a beneficiary. Ms. Simran asks, who all can be executor in a will? Any person who is a major and of sound mind can be appointed as an executor. This can include a spouse, child, friend, or even a professional lawyer or a trusted company. Mr. Karan asks, can we exclude a legal heir from a will? That's a very tricky question. Yes, a legal heir can be excluded, but this is subject to personal laws. For example, under Hindu law, self-acquired property can be freely willed, while Muslim law has restrictions. Clear reasons in the will does definitely help avoid the disputes, though. Mr. Bhuvnesh asks, are paintings tangible or intangible assets? Paintings are tangible assets because they are physical items and they can be seen, touched, and transferred. Miss Ishika asks, can we include pets in a will? No, unfortunately, pets are not considered property under law and cannot inherit assets directly. However, a will can be, I mean, you can appoint a caretaker for the pet under the will and set aside funds for its maintenance and care. Ms. Shalu asks, can we include shares and mutual funds in wills? Yes, definitely. You can include shares and mutual funds. It's an intangible assets. Financial assets can be included. Bonds, bank accounts, they can be included. All right. Uh, I think these are all the questions. Thank you, everyone.